Hello, I'm Kenneth Marcus, Assistant Secretary of Education for Civil Rights at the U.S. Department of Education's Office for Civil Rights. The Office for Civil Rights, or OCR, provides civil rights enforcement and technical assistance services for a variety of programs nationwide.
Hi, my name is Kimberly Ritchie, and I am Principal Deputy Assistant Secretary for Civil Rights here at the Department of Education's Office for Civil Rights. OCR's enforcement jurisdiction includes Title IX of the 1972 Education Amendment Act, which you probably know by its shorthand, Title IX. That law prohibits discrimination on the basis of sex by recipients of federal funds, which include most schools. Sometimes we'll use the term recipients when we mean schools or school districts.
Discrimination can take many forms, but one common form it takes is harassment based on sex, including sexual assault. Over 20 years ago, the Supreme Court held that a school's duty not to discriminate goes beyond just the school itself discriminating against students. It also requires schools to respond appropriately when they learn of allegations of sexual assault between students, or between an employee and a student, or even an employee and another employee.
The Department of Education, along with many other executive branch agencies, has the authority to enact regulations to effectuate Title IX. Until now, however, specific protections against sexual harassment have never been enshrined in law. That's now changed with the final regulations.
The final regulations are designed to create a consistent, predictable, fair, and effective means of ensuring non-discrimination in schools, consistent with everyone's right to free speech and due process. Sexual harassment is a serious problem, and it needs to be taken seriously.
We plan to discuss some of the key features of the new final regulations, which are effective on August 14th, 2020 in this webinar. Of course, we can't address every provision of the final regulations in this video, and you might have some additional questions at the end of this presentation. For technical assistance, you are invited to send an email to OCR's Open Center, which can be reached at open@ed.gov. That's open@ed.gov. Right now, we hope to help students, schools, and the public understand important rights and responsibilities under the new regulations. Among other questions and material, we plan to answer 7 main questions. What is sexual harassment? When is a school on notice of sexual harassment? What must a school do to support alleged victims when it has notice of sexual harassment? What personnel and policies must a school have in place to address sexual harassment? What grievance process must a school generally follow before making a determination as to whether sexual harassment occurred and before disciplining a student for engaging in sexual harassment? What are some other prominent features of the new regulations addressing other topics, for instance, retaliation and record keeping? And finally, how do the final regulations protect free speech when a school responds to sexual harassment?
Hi, I'm William Trackman, Senior Counsel in the U.S. Department of Education's Office for Civil Rights. The first topic that we're discussing today is the definition of sexual harassment. The final regulations provide a definition of sexual harassment that schools must use for Title IX purposes to protect students from sex discrimination. Sexual harassment is conduct on the basis of sex that meets one or more of the following descriptions. The first category is a school employee conditioning an educational benefit or service on an individual's participation in unwelcome sexual conduct. People often refer to this as quid pro quo harassment, offering a benefit in exchange for unwelcome sexual conduct. This is an abuse of a school employee's position of authority and trust. The second category is any type of unwelcome conduct determined by a reasonable person to be so severe, pervasive, and objectively offensive that it effectively denies a person equal access to the school's education program or activity. The third category is sexual assault, dating violence, domestic violence, or stalking, as those terms are defined under other federal laws called the Clery Act and the Violence Against Women Act. Because we are talking about Title IX, which prohibits discrimination on the basis of sex, it's also the case that misconduct that is not based on sex is not sexual harassment under Title IX. Some conduct that meets the federal criminal definition of stalking, for instance, may not be based on sex. At the same time, misconduct that is based on sex does not need to be sexual in nature in order to constitute sexual harassment. While only a school employee can commit quid pro quo sexual harassment, any person might perpetrate the other two categories of misconduct that constitute sexual harassment, whether it's a school employee, a student, or anyone else. We also want to emphasize that anyone, regardless of a person's race, sexual orientation, disability status, or gender identity, might be a victim or perpetrator of sexual harassment. The final regulations protect everyone from sexual harassment under Title IX. Sexual harassment might consist of verbal, physical, or other types of conduct that target a person based on their sex and that the person finds unwelcome. A school's enforcement of Title IX must always be consistent with everyone's free speech rights.
Hi, I'm Samantha Christensen, counsel to the Assistant Secretary for Civil Rights at the U.S. Department of Education's Office for Civil Rights.
One question that you may be asking is whether the location of sexual harassment matters for the purpose of when a school has to respond under Title IX. The answer is that it can matter, although it's a little more complicated than that. When it passed Title IX, Congress covered only sex discrimination against a person in the United States. The final regulations don't change that one way or another. The most important consideration for whether a school must respond to sexual harassment is whether the harassment occurs in a school's education program or activity. The final regulations state that a school's education program or activity includes any locations, events, and circumstances, whether or not these items are on a school's campus or not, where a school exercises substantial control over the context of the alleged harassment and the person accused of committing sexual harassment. Schools must always respond to sexual harassment that happens in school-related circumstances, such as on field trips, academic conferences, or on a school bus. At the post-secondary level, the final regulations also specify that a school's education program or activity extends to any building that is owned or controlled by a student organization if that organization is officially recognized by the post-secondary institution. This applies, for instance, to fraternity or sorority houses, whether on campus or off campus, if the fraternity or sorority is officially recognized by the school and the fraternity or sorority owns or controls their own building. Putting these provisions together, a school's duty to respond is not simply a matter of whether sexual harassment occurred on campus or off campus.
The final regulations state that once a school has actual knowledge of sexual harassment or allegations of sexual harassment, the school has to respond and take action. Our second topic is about what constitutes actual knowledge under the new Title IX final rule. Actual knowledge is notice to the school of an allegation of sexual harassment. A school has actual knowledge when the school has notice that a person may have been victimized by sexual harassment. How is the school put on notice of sexual harassment? Any person, whether the alleged victim or a parent, friend, or bystander, has the right to report sexual harassment to put the school on notice. And sometimes school personnel will personally witness sexual harassment themselves. But who within a school needs to have notice for the school to be considered to have actual knowledge? In all schools, colleges and universities, and elementary and secondary schools, the school must respond whenever the school's Title IX coordinator has notice. Reports can be made to a school's Title IX coordinator by mail, phone, or email at any time, day or night, and also in person. Reports can be verbal or written. Also, in all schools, the school must also respond whenever any school official with authority to institute corrective measures has notice of sexual harassment. For all schools, telling the Title IX coordinator always puts the school on notice. For postsecondary institutions, the school officials in this category may vary from school to school, but again, they will always include the Title IX coordinator. In elementary and secondary schools, telling any school employee always puts the school on notice. Schools must post the Title IX coordinator's contact information on their websites and send notice of that contact information to every student, employee, parent, and legal guardian of an elementary or secondary school student and school union, so that the entire school community is aware of how to report sexual harassment to the Title IX coordinator.
Our third topic is what schools have to do once they have actual knowledge of sexual harassment. Once a school has actual knowledge of sexual harassment in its education program or activity, the school has to respond promptly, and the response cannot be deliberately indifferent to the knowledge of sexual harassment. Another way of thinking about whether a response is deliberately indifferent is asking whether it's clearly unreasonable in light of the known circumstances. As part of a required response, and in order not to be deliberately indifferent, the Title IX coordinator has to respond promptly when there's actual knowledge of an allegation of sexual harassment. At a very minimum, the Title IX coordinator must promptly reach out to the student alleging sexual harassment and confidentially discuss the available options. Those options include receiving supportive measures from the school and choosing whether to also file a formal complaint that initiates an investigation into the alleged victim's sexual harassment allegations. The Title IX coordinator must also inform the alleged victim, 1, that supportive measures are available to them to restore access to the school's education program or activity with or without the filing of a formal complaint. And 2, how the process to file a formal complaint works.
As Samantha noted, A required part of the school's response is to offer supportive measures to the alleged victim of sexual harassment, regardless of whether a formal complaint is also filed. Supportive measures may also be offered to the person accused of sexual harassment. What are supportive measures? Supportive measures are free, individualized services designed to restore or preserve equal access to education, protect safety, or deter sexual harassment. They are offered without a fee to either an alleged victim or the accused person. There doesn't need to be a formal complaint for either person to receive supportive measures. The key to supportive measures is that they support a student and that they aren't punitive or disciplinary with respect to another student. Supportive measures are designed to restore or preserve equal access to the recipient's education program or activity without unreasonably burdening any other person. Supportive measures might include counseling, extensions of deadlines or other course-related adjustments, modifications of work or class schedules, campus escort services, mutual restrictions on contact between the parties, changes in work or housing locations, leave of absence, increased security, and monitoring of certain areas of the campus and other similar measures. When alleged sexual harassment occurs in a school's education program or activity, the Title IX coordinator has to inform the victim of the right to supportive measures, even if no formal complaint is filed, and the school must consider the alleged victim's wishes when it comes to their request for supportive measures.
The school must keep confidential any supportive measures provided to the alleged victim or the accused person, to the extent that confidentiality does not impair the school's ability to provide the supportive measure. And the Title IX coordinator is responsible for coordinating the effective implementation of supportive measures.
Sometimes a student will choose to file a formal complaint. A formal complaint is an official document alleging sexual harassment, and schools must investigate the allegations made in a formal complaint. A formal complaint has to be filed by the student or their parent or legal guardian as appropriate, or signed by the Title IX coordinator. Formal complaints can be filed by the Title IX coordinator in person, by mail, by email, and any other method that the recipient also allows. Even if a student opts not to file a formal complaint, the school's Title IX coordinator may in some cases decide to file a formal complaint on their own, which starts an investigation. Now let's turn to our fourth topic and talk about what schools must do in terms of their written policies for dealing with sexual harassment. Some policies will deal with the grievance process when a formal complaint is filed, so that will help guide us when we actually walk through those provisions right after discussing the written policies. Every recipient must designate and authorize at least one employee to coordinate its Title IX efforts. That person must be called a Title IX coordinator, which we've alluded to already. The recipient has to give the name or title, office address, electronic mail address, and telephone number of the employee or employees designated as the Title IX coordinator to all of its students, applicants for admission or employment, employees, parents or legal guardians of elementary and secondary school students, and all unions or professional organizations that have collective bargaining agreements or other professional agreements with the recipient. Any person may contact the Title IX coordinator in person, by mail, by telephone, or by electronic mail, or by any other means that results in the Title IX coordinator receiving the person's verbal or written report. Such a report may be made at any time, including during non-business hours, by using the telephone number or electronic mail address, or by mail to the office address listed for the Title IX coordinator. A person needs to be able to make a report to the telephone number, electronic mail address, or mail address at all times.
In addition to the notice of the Title IX coordinator and their contact information, the recipient also has to disseminate to the same groups a notice that it has a policy against discrimination on the basis of sex, and that it is required by Title IX not to discriminate on the basis of sex. The recipient also has to display and post the Title IX coordinator's contact information and the policy against discrimination on its website and its handbooks and in its catalogs. In addition to the written policy surrounding non-discrimination and the Title IX coordinator, recipients also have to adopt and publish written grievance procedures that provide for a prompt and equitable resolution of student and employee complaints, along with a grievance process that complies with additional standards for sexual harassment allegations. The grievance procedures have to be provided to the same groups mentioned above in the context of the non-discrimination and Title IX coordinator obligations. The recipient has to provide information to the same groups about how to file a formal complaint of sexual harassment and how the recipient will respond when a formal complaint is filed.
It's important for a school's educational community to be aware of how to report sexual harassment, how to file a formal complaint of sexual harassment, and how the school will respond to reports and formal complaints. The final regulations require each school to notify all students and employees, parents and legal guardians of elementary and secondary students, and school unions of the school's sexual harassment grievance process.
The final regulations announce requirements that schools must have in their written grievance policies. Most broadly, school grievance procedures cannot treat people differently on the basis of sex when the school investigates or reaches determinations regarding responsibility. Also, schools must adopt rules in accordance with these final regulations, and any additional rules that the school chooses to adopt that do not conflict with these final regulations must apply equally to complainants and respondents. Note that whether or not a grievance process has begun, the final regulations refer to an alleged victim of sexual harassment as a complainant and to a person accused of sexual harassment as a respondent. The final regulations also require every school's grievance process to contain 10 other, more specific items. First, the school's grievance process must treat complainants and respondents equitably by providing remedies to a complainant if a respondent is found responsible, and by following the prescribed grievance process, imposing discipline on a respondent. The remedies for a complainant have to be designed to restore or preserve equal access to the school's education program or activity. Unlike supportive measures in place with or without a grievance process pending, a complainant's remedies can be punitive or disciplinary against the respondent.
Second, the grievance process must ensure an objective evaluation of all relevant evidence, including inculpatory and exculpatory evidence. And credibility determinations can't be made on the basis of a person's status as a complainant, respondent, or witness. Third, the individuals involved in the process, like the Title IX coordinator, investigators, decision makers, or facilitators of informal voluntary resolution efforts, must not have any bias or conflict of interest. These individuals must also be trained. The training has to include, among other things, the definition of sexual harassment, the scope of the recipient's education program or activity, how to conduct an investigation and grievance process, including hearings, appeals, and informal resolution processes, as applicable, and how to serve impartially, including by avoiding prejudgment of the facts at issue, conflicts of interest, and bias. It also has to include training on any technology to be used at a live hearing and on issues of relevance of questions and evidence, including when questions and evidence about the complainant's sexual predisposition or prior sexual behavior are not relevant. A recipient also must ensure that investigators receive training on issues of relevance to create an investigative report that fairly summarizes relevant evidence. The materials used to train Title IX personnel can't rely on sex stereotypes, must promote impartial investigations and adjudications, and must be posted on each school's website. And if a school does not maintain a website, the school must make them available for public inspection upon request.
Fourth, the respondent must be presumed not responsible, so that any finding of responsibility only comes at the conclusion of a grievance process. Fifth, the grievance process must include reasonably prompt timeframes for resolving formal complaints of sexual harassment. Note that the final regulations do permit temporary delays of these timeframes, but only for a good cause. Good cause can include law enforcement activities, the absence of a party or witness, the absence of a party's advisor of choice, or the need to provide language assistance or accommodation of disabilities.
Sixth, the grievance process must describe or list the range of possible remedies and disciplinary sanctions that could occur following a determination of responsibility. Seventh, the grievance process must state which standard of evidence the school will use to reach a determination regarding responsibility, to be used for all sexual harassment proceedings. For that standard, schools can choose between the preponderance of the evidence standard and the clear and convincing evidence standard. But whichever standard the school chooses, it has to use that standard for all formal complaints of sexual harassment, whether the respondent is a student or employee, including a faculty member. That also means that a recipient cannot choose preponderance of the evidence as a standard for some cases of sexual harassment, but clear and convincing as a standard for others. All sexual harassment proceedings must have the same standard of evidence.
Eighth, the written policies have to contain information about the right to appeal the result of a grievance process. Schools must offer an appeal to every party on certain bases that we'll describe later on in this webinar. And schools also have the option to expand the bases on which an appeal may be taken, as long as they apply those bases equally to both parties. Ninth, the school's grievance process must describe the range of supportive measures, like those we previously described, available to complainants and respondents.
10th, the school's grievance process must explain that no information protected by a legal privilege, such as the attorney-client privilege or the doctor-patient privilege, can be used during an investigation unless the person holding that privilege has waived it. In the same vein, during a grievance proceeding, neither a party nor the school is allowed to seek, permit questions about, or allow the introduction of evidence that is protected by a recognized privilege. That includes the attorney-client privilege, among other privileges. Of course, individuals can always opt to waive their own privileges if they want, but they don't have to.
Okay, our fifth big topic today is the grievance process once a formal complaint has been filed. When a school is investigating and reaching determinations about allegations in a formal complaint of sexual harassment, the school must comply with specific requirements. As a reminder, a formal complaint can be filed either by a complainant or their parent or guardian, as appropriate, or signed by the Title IX coordinator.
Two more notes before we describe what the school's investigation and decision-making process must look like. First, whether or not a grievance process is underway, a school can remove a respondent from the school's education programs or activities on an emergency basis if the respondent poses an immediate threat to anyone's physical health or safety. There are additional requirements for emergency removal proceedings that schools should consider if they institute this process. Second, if the respondent is a school employee, the final regulations don't prevent a school from placing that employee on administrative leave during the investigation. Of course, the employee may have other rights under a collective bargaining agreement or the Americans with Disabilities Act or Section 504 of the Rehabilitation Act of 1973. As we start discussing the investigation and grievance process, remember that the final regulations state emphatically that the grievance process cannot itself discriminate against a complainant or a respondent on the basis of sex. That means, for instance, that practices must apply equally to both complainants and respondents, either of which can be male or female, and can't discriminate as between men and women, notably with respect to credibility determinations.
When the school begins an investigation, it has to provide the parties, that is, the complainant and the respondent, written notice of certain information. For instance, it has to give notice to the parties of the school's grievance process, which complies with the 10 items we listed before. It also has to include whether there's an opportunity to engage in informal resolution. Schools don't have to offer informal resolution processes, but if they choose to, it's important that they are mentioned in this initial notice. The written notice also needs to give the parties several pieces of additional information. First, the written notice must describe key details of the alleged sexual harassment incident, such as who was involved in the incident, the date and location of the incident, if known, and the alleged misconduct that constitutes sexual harassment. Second, the notice also has to include a statement that the respondent is presumed not responsible at the outset of the process and can only be found responsible after the grievance process concludes. Third, this notice also has to include a statement that the parties are entitled to an advisor of their choice. The advisor can be an attorney, but doesn't have to be. Fourth, the notice also has to include a statement that the parties can request to inspect and review certain evidence. Fifth, the notice also has to include information regarding any provision in the recipient's code of conduct, if it exists, that prohibits knowingly making false statements or submitting false information during the grievance process. Note that a satisfactory notice has to be provided to the parties before any initial interview with the respondent occurs, and has to give the parties sufficient time for a respondent to prepare before an initial interview.
It's important to remember that a school must investigate every formal complaint, and the school must send the initial written notice that we've described as soon as the school receives any formal complaint. But there are some instances where a formal complaint or some of the allegations in it must be dismissed outright by the school. And there are other situations where a complaint can be dismissed by a school within its discretion. The final regulation includes requirements for mandatory dismissals and discretionary dismissals. First, let's discuss mandatory dismissals. A school must dismiss a complaint that does not describe conduct that meets the definition of sexual harassment that we discussed earlier, or that alleges sexual harassment that did not occur in the school's education, program, or activity, or that did not occur in the United States at all. The final regulations do not prevent a school from addressing misconduct that violates a state law or violates the school's own code of conduct, even if the misconduct is not sexual harassment under Title IX. Now, let's turn to discretionary dismissals. There are circumstances when a school is allowed to use its discretion to dismiss a formal complaint or some of the allegations in it. A school can choose to dismiss if the complainant notifies the Title IX coordinator in writing that the complainant wishes to withdraw the formal complaint or some of its allegations. A school can also choose to dismiss if the respondent is no longer enrolled or employed by the school, or if specific circumstances prevent the school from gathering evidence sufficient to reach a determination about the allegations. In each of these situations, the school can dismiss the formal complaint, but it also has the option to proceed if it doesn't think dismissal is appropriate. Whenever a school dismisses a formal complaint or any allegations in it, the school has to promptly send written notice of the dismissal and the reasons to the parties. As we will mention later, both parties have the right to appeal a school's dismissal decision.
As a school's investigation proceeds, the school must give both parties specific equal rights and protections. These rights and protections apply whether the complainant filed a formal complaint or whether the Title IX coordinator began the investigation by signing the formal complaint. We should also mention that when the Title IX coordinator signs a formal complaint, the school does not treat the Title IX coordinator as the complainant or as a party to the grievance process. The Title IX coordinator always remains impartial towards the complainant and the respondent. But despite being the one with the burden of proof in any given grievance process, the school is not allowed to access a party's personal records if they are maintained by a physician, psychiatrist, psychologist, or other professional for the purpose of treatment to the party. Only if a party voluntarily consents, in writing, to the use of these materials, can the school access them.
The school has an ongoing duty to let the parties prepare for the time when a determination of responsibility will be made. The school must provide an equal opportunity for the parties to present witnesses and evidence, including expert witnesses, as well as inculpatory or exculpatory evidence. The school also can't restrict the ability of either party to discuss the allegations under investigation or to gather and present relevant evidence. The school has to provide the same opportunities to the parties to have others present during the grievance proceedings, including access to an advisor of choice for any meetings or hearings.
There are other requirements as the school goes through the grievance process. The school has to provide written notice of the date, time, location, participants, and purpose of all hearings, interviews, or other meetings, with sufficient time for the party to prepare. That goes for both complainants and respondents. The school must also provide equal opportunities for the parties and their advisors to inspect and review the evidence obtained by the school as part of its investigation if the information is directly related to the allegations raised in the formal complaint. That could include documents, notes from interviews with students or employees, or other types of evidence that the school gathers. And it even includes evidence that the school doesn't think it will use or that it plans to use before reaching a determination as to whether sexual harassment occurred. The evidence can be sent in electronic format or hard copy. That evidence must later be available at any hearing if a hearing occurs.
After gathering evidence, the school needs to prepare an investigative report on the allegations of the formal complaint. The regulations don't say how long the report has to be, but it does need to fairly summarize the evidence that the school has gathered about the alleged incident. But this report can't be finalized until the evidence sharing we just mentioned happens. And even then, a school has to give the parties at least 10 days to respond to the evidence in writing. If a response is submitted, the school must consider that response before finalizing the investigative report. The investigative report can then be finalized and provided to the parties. That report must be circulated to the parties at least another 10 days before any determination of responsibility, or 10 days before a hearing, if a hearing happens.
You might be wondering whether a hearing must take place where the parties get to ask questions and present evidence to the person who will be reaching conclusions about the case. The answer depends on the type of school investigating the allegation of sexual harassment. For example, the elementary and secondary schools have the option, but never the obligation, to hold a hearing. But even without a hearing, the elementary or secondary school must give the parties equal opportunity to submit relevant written questions to each other before the decision maker reaches a determination. If a decision maker opts not to ask a question, it has to explain to the parties why the question isn't relevant to the issues in the hearing. It's important to note that the final regulations state that questions and evidence about a complainant's prior sexual history are not relevant, with two limited exceptions that we'll explain in a moment.
at the post-secondary level, the school must hold a live hearing. A live hearing is an opportunity for both parties to tell their side of the story in front of the decision maker. During a live hearing at a college or university, the parties' advisors must be allowed to cross-examine other parties and witnesses with real-time back-and-forth questions and follow-up questions, including questions that challenge credibility. But no party can ever be allowed to personally question or cross-examine anyone. If any party requests it, the entire live hearing must be held with the parties located in separate rooms, with technology enabling everyone to see and hear each other, so that parties never need to face each other in person during a live hearing. Cross-examination simply means that a party's advisor asks questions that might challenge the other party's denials or allegations. The purpose is to help the decision maker arrive at a factually accurate decision about what happened. The final regulations specify that cross-examination questions must be relevant, and that decision makers must decide if a question is relevant before the party or witness has to answer it. In addition, a complainant's privacy must be protected by only allowing questions or evidence about prior sexual history in two narrow circumstances: where such information is offered to prove that someone other than the respondent committed the alleged sexual harassment, or it relates to sexual behavior between the complainant and the respondent and is offered to prove consent. Again, no party is ever allowed to personally cross-examine anyone. So what if a party shows up to a hearing without an advisor? The final regulations require the school to provide that party with an advisor of the school's own choosing, free of charge, solely for the purpose of conducting cross-examination on that party's behalf. An advisor chosen by the school does not need to be a lawyer. In these situations, the advisor's only job at the hearing is to relay a party's relevant cross-examination questions to other parties and witnesses, so that the parties themselves never personally confront anyone. By hearing each party's version of events and hearing each party answer questions about their version of events, the neutral, unbiased decision maker is more likely to reach an accurate determination regarding responsibility.
What if a party or witness chooses not to appear at the live hearing or chooses not to answer cross-examination questions? First and foremost, the final regulations protect every person's right to choose to participate or not to participate in any part of a grievance process. No one should be forced, threatened, coerced, or discriminated against for choosing not to be part of the school's grievance process. If a party or witness chooses not to appear at the live hearing or not to answer cross-examination questions, the decision maker excludes that party's or witness's statements and evaluates any evidence that doesn't involve those statements. The decision maker must never make inferences about the determination regarding responsibility based on the fact that a party or witness didn't come to the hearing or submit to cross-examination. To reiterate, a school cannot draw an inference about the refusal to testify, either positive or negative. To make it easier for schools to hold live hearings that accommodate the schedules of parties, advisors, and witnesses, the final regulations allow a school to hold the entire live hearing virtually, or a school may allow some participants to appear virtually with technology that allows everyone to see and hear each other. Schools also have to create an audio or audiovisual recording or transcript of any live hearing and make it available to the parties for inspection and review. It's important to remember that a school must always comply with disability laws so that individuals with disabilities who participate in a school's grievance process are appropriately accommodated, including with respect to the use of technology and the reliance on visual, auditory, or written modes of communication.
In an elementary or secondary school, whether or not a hearing was held, and in a post-secondary institution, after a live hearing has been held, the school's decision maker needs to objectively evaluate the relevant evidence and reach conclusions about whether the respondent is responsible for the alleged sexual harassment. The school's decision maker needs to use independent judgment, so the decision maker cannot be the same person who conducted the investigation and cannot be the school's Title IX coordinator. We've used the word adjudicator or decision maker a few times in reference to the person or people who weigh the evidence, apply the standard of proof, and make a decision. Who are these people? Well, the final regulations offer some requirements as to who these people cannot be. First, the person or people who make the decision about responsibility can't also be the ones who gathered the evidence in the first place, and they can't be the Title IX coordinator. There has to be a separation between these roles under Title IX. In terms of who the adjudicators can be, the adjudicators or decision makers must be free from conflicts of interest or bias for or against complainants or respondents, and must receive special training about how to be impartial and how to decide what evidence is relevant. The decision maker will weigh the relevant evidence and decide whether it meets the school's standard of evidence for sexual harassment allegations.
Once the evidence has been heard and the adjudicator or adjudicators proceed to make a finding, they have to comply with several requirements before issuing the determination. First, the determination has to be written and has to include a number of parts. One, it needs to include the portion of the school's policies that was violated. That can be a school's Title IX policy or its general policy against sexual harassment if it adequately tracks the final regulations. Two, the written determination has to describe all of the procedural steps that were taken by the school on the way to getting to that point, including describing all of the notices and interviews that took place, any site visits that occurred, and the hearing itself. Third, the written determination needs to include a findings of fact section, where the adjudicator explains what facts were introduced at the hearing. Fourth, it has to include a section that draws conclusions after applying the facts to the portion of the school's policy that applies. For each allegation that was made in the formal complaint, the written determination has to provide a statement and rationale for the conclusion as to each allegation in the formal complaint. Fifth, the written determination needs to include a statement and rationale for the ultimate determination of responsibility. Sixth, the written determination needs to describe any disciplinary sanctions that the school will impose on the respondent and state whether the school will provide remedies to the complainant. Where the respondent is determined to be responsible for sexually harassing the complainant, the Department of Education will not second-guess the school's decisions about disciplinary action against the respondent. The final regulations require the school to give the complainant remedies designed to restore or preserve the complainant's educational access. These remedies might be some of the same individualized services that schools must offer as supportive measures, but because the respondent has now been found responsible for sexual harassment, remedies may burden the respondent. For example, a complainant's remedies might include a one-way no-contact order against the respondent that forbids the respondent from participating in the same extracurricular club or team that the complainant has joined. The school's Title IX coordinator is responsible for effectively implementing remedies for the complainant. Seventh, The written determination must include a statement and rationale for any remedies for the complainant, addressing how those remedies will restore or preserve equal access. Eighth, the written determination needs to include a statement of the recipient's procedures, a statement that the parties have a right to appeal the initial determination regarding responsibility, and the permissible bases for appeal.
The school must send the written determination to the parties simultaneously, along with information about how to appeal the determination. The decision is final either 1, if the parties don't appeal, or 2, at the conclusion of the appeal if either party files an appeal. A school has discretion to set deadlines for when an appeal must be filed, bearing in mind the obligation to conclude the entire grievance process and bring resolution to the situation for both parties within a reasonably prompt time frame. Separately, the Title IX coordinator is responsible for carrying out the remedies contained in the written decision.
The new rule also addresses the rights of the parties to appeal a ruling. The school has to offer both parties an opportunity to appeal. Appeals can be taken from 2 different steps in the process. One is the dismissal we discussed before, where a school must dismiss some complaints sometimes and is allowed to dismiss other complaints in its discretion at other times. Either party can appeal those dismissals. The other chance to appeal is to appeal the ultimate finding of responsibility at the end of the grievance process. The rule sets out that schools have to allow appeals on a handful of bases. But schools have the ability to expand those bases if they want, and if they do so, equally for complainants and respondents. First, either the complainant or the respondent can appeal on the grounds that a procedural irregularity affected the outcome of the matter. Second, either party can appeal on the grounds that new evidence has been discovered that was not reasonably available at the time of the determination on responsibility or dismissal. Third, either party can appeal on the grounds that there was a conflict of interest on the part of a Title IX coordinator, an investigator who compiled evidence, or a decision maker, and that the conflict of interest affected the outcome. Fourth, schools can offer additional grounds for appeals if they want to, so long as the grounds apply on an equal basis to the parties.
What if a party appeals? If a party does file an appeal, the recipient has to notify the parties in writing and implement appeal procedures equally. Both parties must have equal opportunity to submit a written statement supporting or challenging the outcome. Importantly, the person who decides the appeal cannot be the same person who reached the determination regarding responsibility or the same person as the investigator or Title IX coordinator. This requirement increases the chances that any error that led to the first outcome will be corrected by the school on appeal. After considering the parties' written statements, the decision maker on appeal has to issue a written decision and send it to the parties simultaneously. At that point, the school's determination about whether the respondent is responsible for the sexual harassment allegations becomes final.
In appropriate cases, the school may facilitate a voluntary, informal resolution of the formal complaint. There is an important exception, however. A school must never facilitate informal resolution of allegations that an employee sexually harassed a student. In other situations, the school has discretion to choose to offer and facilitate options such as mediation as a way of resolving the allegations in a formal complaint. The final regulations place critical parameters around this option, however. The most important restriction on any informal resolution is that it must only be attempted if each party enters the process completely voluntarily. A school can never force, threaten, or require any party, complainant, or respondent into going into informal resolution. Schools also can't force students to agree to informal resolution ahead of time as a condition for going to school, or force employees to agree to informal resolution as a condition of employment. Further, if informal resolution proceeds, the school must provide a facilitator who is free from conflicts of interest or bias and who has received special training.
Assuming there is mutual, voluntary agreement to engage in informal resolution, the school still needs to provide complainants and respondents with notice of the allegations, notice of their rights, information about whether an informal process is confidential, and assurances that any party may withdraw from the informal process and resume the grievance process at any time before an agreement has been reached.
Our sixth topic is some of the other prominent features of the new regulations, such as retaliation and record keeping. Under the new regulations, schools also have specific record-keeping duties to make sure that they retain relevant information. The duty extends for 7 years and includes several categories of documents. First, records of a school's investigation, including any determination regarding responsibility, and any appeal or informal resolution, and the audio or audiovisual recording or transcript of any hearing, and a record of any discipline against a respondent or remedies provided to a complainant. Second, schools need to keep records of any appeal and the materials associated with an appeal, such as the written statement submitted by the parties. Third, schools need to keep records of any informal resolution process, such as notices that go out to the parties preceding informal resolution and other documents created during the process. Fourth, schools must retain all materials used to train Title IX coordinators, investigators, decision makers, and any person who facilitates an informal resolution. These materials also have to be posted on a recipient's website or made available for public inspection if the recipient doesn't have a website. Fifth, schools must keep records of the supportive measures that they took in response to a report or complaint of sexual harassment. This includes situations when a recipient offers supportive measures to a complainant only, and where the alleged victim of sexual harassment opts not to proceed with a formal complaint. Even in these cases, a school's record keeping has to include the basis for its belief that it was not deliberately indifferent and that it took measures designed to restore or preserve equal access to its education program or activity. These record-keeping requirements help hold schools accountable for meeting their Title IX obligations. If the department needs to investigate whether the school responded appropriately to a sexual harassment situation, the school will have documentation describing its response. Requiring these types of records also reminds a school to carefully consider every response to sexual harassment, making it more likely that every complainant and every respondent will receive the rights and benefits provided for in the final regulations.
We understand that fear of retaliation is one reason why some people are reluctant to report sexual harassment, file a formal complaint about sexual harassment, or participate in a grievance process. The final regulations state clearly that no school or person is allowed to retaliate against anyone for exercising rights under Title IX. If any person believes they have been intimidated, threatened, coerced, or discriminated against in an effort to chill the exercise of Title IX rights, the person retaliated against can file a complaint with the school, and the school must have procedures in place for the prompt and equitable resolution of such complaints. To make retaliation less likely and to generally protect parties' privacy in Title IX situations, the final regulations also require the school to keep the identities of parties and witnesses confidential, unless disclosure of someone's identity is required under other laws or is necessary in order to conduct the grievance process.
One form of retaliation that the final regulations call attention to is when a school charges a person with a code of conduct violation for the purpose of discouraging the person from pursuing a sexual harassment report or formal complaint, or exercising any other Title IX rights. The final regulations specifically state that if a code of conduct charge is for a violation unrelated to sexual harassment, yet arises from the same facts as a sexual harassment allegation, that may be prohibited retaliation. The final regulations also state that it's not retaliation for a school to punish someone for making a bad faith, materially false statement during a Title IX grievance process, as long as the school does not draw that conclusion solely based on the outcome of the case. The anti-retaliation provision in the final regulations also expressly states that engaging in protected speech under the First Amendment never constitutes retaliation. This is just one of the ways the final regulations ensure that Title IX is enforced consistent with everyone's First Amendment rights.
Our seventh and last topic is how the new regulations protect free speech. In its 2001 revised sexual harassment guidance, the department recognized that Title IX is not intended to regulate the content of speech, and that the offensiveness of a particular expression as perceived by some students, standing alone, is not a legally sufficient basis to establish a sexually hostile environment under Title IX. The final regulations echo this guidance and follow other long-standing department guidance that since 2003 has advised schools, students, and school employees that OCR can never require a school to violate the First Amendment. The final regulations codify this fact. As part of the federal government, the department is never allowed to interpret laws or regulations in a way that makes a school restrict constitutional rights, including free speech rights. And when OCR investigates a school for possible Title IX violations, OCR will never view a school's attempt to suppress free speech as an appropriate response to sexual harassment. In other words, a school can never rely on restricting constitutionally protected speech as a way of showing the school satisfied its duty not to be deliberately indifferent to alleged sexual harassment.
What if you have further questions? Understandably, people will have questions about the new regulations. In that regard, the department has prepared for a robust effort to engage in technical assistance with educators and the public, which includes the creation of a new Open Center. The Open Center is standing ready to field questions regarding the new regulations and the important topic of sexual harassment, and can be reached at this email address: T9questions at ed.gov. The new regulations become effective on August 14th, 2020. To file a complaint online or learn more about the complaint process, please visit orcas.ed.gov. That's OCRCAS.ed.gov. Additionally, be sure to check out OCR's new series of short webinars available on YouTube covering an array of relevant topics. Thank you for your commitment and the hard work that you do every day to invest in our nation's children and our future. On behalf of all of us here at OCR, we appreciate that each of you does this work because you know it makes a difference in the life of students who attend your school. We look forward to continued cooperation between your school and the U.S. Department of Education to improve educational access for all of our students.